Call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled James Leone v. Department of Labor, case number 25AP214. Appellant James Leone is self-represented. Representing the appellee, the Department of Labor, is attorney Jared Adler.
Okay, thanks very much. Good morning, everybody. Mr. Leone, can you hear me, sir?
Yes, sir.
All
Good
right,
morning.
and good morning. And we can hear you. You
Great.
understand you have 5 minutes, and we'll try to give you an alert when you've got a little bit of time left. So please go ahead.
Yes, Your Honor. Good morning, Your Honors. I appreciate and thank the court for taking the time to hear my case. Vermont's Department of Labor states that an
Sure.
individual can only receive unemployment benefits if they are unemployed through no fault of their own. I meet that standard. I worked as a seasonal asphalt truck driver for Jay Hutchins out of the Irisburg location in 2024. Asphalt work ends in the winter. I was laid off due to lack of work. There was no misconduct, no performance issues, no attendance issues, and no voluntary quit. The employer does not dispute this. Under Vermont law, being able and available means being physically and mentally capable of working, ready and willing to accept suitable work, actively seeking work, and remaining genuinely attached to the labor market. I met every part of that definition. I worked the entire season without issue in the same physical, mental, and logistical environment that existed when I filed my unemployment claim. Nothing materially had changed between my last day of work and the day that I filed. If I was able and available to perform my job every day during the season, then I remained available and able after the seasonal layoff unless something changed. Nothing did. I acted in good faith at all times. I'm a reliable employee. I was never late, never missed work, and never took unapproved time off. I was even forced to live in my car near the job site at a campground for months to remain close to work. This is due to the challenges and costs of availability for seasonal work housing in the Northeast Kingdom. However, I was able to find housing when the weather began to change in the fall. I bring this up not for sympathy, but to illustrate my work ethic and commitment to finishing the season with Jay Hutchins. During this time, I also experienced significant personal loss. My mother passed away in October 24, and one of my closest friends passed away in early March 2025, just 4 months later. I experienced grief and depression during this period that was completely foreign to me. However, during that challenging time, I never stated that I was unable to work. I never withdrew from the labor market, and I never refused work. I remained physically able, mentally able, and willing to accept suitable work if presented with it. The department determined that I was quote unquote regularly traveling in several states and internationally. This is simply incorrect. Regular travel is defined as predictable travel occurring daily, weekly, monthly, or yearly. My travel does not meet that definition. I visited family in Ohio for Thanksgiving and Christmas, which is reasonable by most accounts. And during the initial claim intake on November 25th, 2024, the department representative found to be no issue. My family and I were and still are grieving my mother's death, so holidays are very important to us, as you can imagine. I had one pre-planned vacation in late January, which is where the claim representative took issue. These were, however, isolated one-time events. I contacted the department on multiple occasions and specifically asked whether taking a vacation while unemployment was allowed. I was told yes on both occasions, most recently by Taylor on December 2nd, 2025. She explained to me, do not file when you are gone, reopen the claim when you return, and file the following week. Very simple. I would have followed these instructions exactly had I been instructed to do so in my initial claim. I've relied on the department's guidance and acted honestly and transparently throughout this case. In regards to missing an initial phone hearing on April 1st, 2025, this was due to a mailing issue with my Ohio P.O. box. The department rescheduled the hearing resolving that issue. I remained within reasonable distance to work, if called. Seasonal asphalt work does not exist in the winter, as I mentioned, and I was never contacted with any other work nor refused any. At no point did I leave the labor market. Without conceding that I was not able and available, if the court determines that the Thanksgiving holiday week, the Christmas holiday week, or the pre-planned vacation week should be excluded, I'm willing to accept a lawful adjustment for those specific weeks only. Excluding those weeks, I would be eligible for 13 weeks of benefits resulting from a seasonal layoff through no fault of my own. I offer this not as an admission, but as a reasonable alternative resolution consistent with Vermont law. In closing, I was unemployed through no fault of my own. I met Vermont's definition of able and available for work before, during, and after the
You have
season.
1 minute, sir. You have 1 minute.
Thank you, Your Honor. The denial is based on a misunderstanding of reasonable holiday travel in one single vacation, not on any failure to meet eligibility requirements. I respectfully request that the denial be reversed. Thank you.
Okay, thank you very much. We'll turn to counsel for the appellee. Please start by introducing yourself, identify your client, and then proceed.
Thank you. Good morning, Your Honors. Jared Adler, representing the Vermont Department of Labor. The decision of the Employment Security Board should be affirmed for two reasons. First, the evidence that's in the record supports the board's conclusion that the appellant's travel schedule imposed significant limitations on his availability for work. And second, the appellant failed to meet his evidentiary burden to demonstrate availability for work. So the evidence in this case is fairly limited. The initial statements, however, provided by the appellant to the department are very illuminating, and they establish that he was not available for work. So when the appellant was filing his initial claim at the end of November 2024, appellant conceded that he was not available for work as he was traveling in several states and would not be in any state long enough to work. This is found at page 25 of the appellate volume. Now, his later representations in his appeal notices and in his argument this morning are inconsistent with that initial statement to the department about his availability for work and how his travel schedule could impact that availability. The appellant's accounting demonstrates that he was not attached to any specific labor market. He was living, as he states, approximately 1 hour from the Vermont border in Quebec during some portion of his unemployment period. He was spending time in Vermont. He was traveling to Ohio, which is where he registered his mailing address. And as he states, he had a pre-planned trip abroad during his unemployment period. His mailing address, as he stated, was in Ohio at his presumably his family home, and that resulted in his missing of the first evidentiary hearing and impacted his ability to participate in the evidence gathering process. And as a result, the evidence that's available in the record is limited as to his availability for work. And the appellant bears the evidentiary burden on appeal of establishing that he was available for work. He did not initially provide requested information to the claims adjudicator, as noted in the determination found at page 23 at the appellate volume. He did not participate in the evidentiary hearing and thus did not offer testimony to the administrative law judge. And as he stated, this is because he had a mailing address in Ohio that presumably was not being checked regularly for incoming mail, and thus he did not know that an evidentiary hearing was scheduled at the time that it was before the department. So the absence of any testimony, the absence of evidence establishing that he was available for work through introducing evidence of work searches or job contacts mean that he has not met his evidentiary burden here. And I'll rest my argument there, and I'm happy to answer any questions the court may have. Thank you.
Okay, thank you. I don't see any hands. Does the appellant have any time?
Yes, appellant has 37 seconds remaining.
Okay, Mr. Leone.
I believe I was acting accordingly and was able and available for work. My fiance lives in Quebec, and I worked for two different companies for over
Lost
2
you.
years. Mhm.
Okay, anything else, sir?
I believe I'm entitled to the 13 weeks of unemployment. I think I acted as I was directed to do. As far as traveling regularly, I just think that that is actually incorrect. At the very beginning, when I spoke to the person who took my claim after being on hold for 3.5 hours, which I think needs to be improved in the system, I was initially approved. When she knew that I was going back to Ohio to visit family for holidays, when she found out that I was being honest and upfront and saying that I had a vacation planned, that's when she went back and said, I'm going to unapprove this. I never said that I was unavailable for work for traveling.
Okay.
I guess the big question, Your Honor, is, and nobody, but according to the Department of Labor, you are allowed to take a vacation and do the proper filing. If I would have been directed from that from the beginning, I don't think any of us would be here right now.
All right. Your time has expired. Thank you.